Hello and welcome back to Highway to NIL, the podcast series that discusses legal developments in the name, image, and likeness, or NIL space. NIL, of course, affects colleges and universities all over the country, particularly those in Division I athletics. And in this podcast series, we delve deep into the current NIL rules impacting colleges and universities and their compliance departments. I am, of course, Cal Stein, a litigation partner at Troutman Pepper Locke. And today I am joined by Highway to NIL OG Chris Brolley, and we are going to be discussing the latest guidance published by the NCAA called Question and Answer, Implementation of the House Settlement. This was released on June 13th, 2025. Now, this is a 35-plus page document chock full of helpful information and way too much to go through in a single episode. So today, what we're going to focus on is what this document has to say about enforcement of NIL rules going forward in the post-House settlement world. What's enforcement going to look like? Who will be enforcing the rules? And what rules are most likely to be enforced? And before we do all of that, though, everyone already knows Chris, but Chris, why don't you go ahead and introduce yourself one more time?
As you noted, Chris Brolley. I'm a senior associate resident of our Philadelphia office. Been working with you, Cal, on NIL matters, speaking at conferences for the last several years, and looking forward to jumping into this, as you noted, lengthy Q&A document.
All right, great. Well, thanks for being here, Chris. So let's start with a little bit of background on this Q&A document. It was developed by the NCAA and the defendant conferences, which of course are the ACC, the Big Ten, the Big 12, the Pac-12, and the SEC. Now, the stated purpose of the guidance is to provide guidance to Division I members on the implementation of the House settlement. Now, this Q&A is not exhaustive. It specifically says that. And it also says there is a possibility, if not an expectation, that the document will be updated over time. Now, the Q&A is divided into 6 general sections: general information, changes to Division I legislation, roster limits, institutional benefits and the benefits cap, i.e. money from schools to student athletes, non-institutional NIL and NIL Go, i.e. boosters, collectives, associated entities, individuals paying NIL. And then the last section is on enforcement rules and process. And as I mentioned, we're not going to talk about all of these today. We're only going to talk about the components that we think bear on enforcement. And what better place to start talking about enforcement than with the final section of the QA, which is called Enforcement Rules and Process. So let's start with that section and talk about what does it look like. And the first thing we want to talk about is the newly formed College Sports Commission. Chris, tell us what the Q&A says about that and what it is.
Yeah, I think it's interesting is a lot of our listeners and people that have been following NIL for the last, maybe not even a couple of years, but maybe several months since the settlement was preliminarily approved and finally approved. The NCAA essentially abdicated its role in enforcement and created this College Sports Commission, as you noted. It is the designated enforcement entity that will be looking over all of these NIL deals and making sure that all of them are in compliance with its rules. And the College Sports Commission, as its own website states, will help facilitate revenue sharing in college sports, making sure NIL deals made between student athletes and third parties are fair and comply with the rules. And as part of schools that opted into the House settlement, they must agree that the College Sports Commission has the authority to investigate and enforce the NCAA bylaws. And they specifically are in charge with enforcing the rules that were developed as part of the settlement agreement. So as we've talked about at length, these are the roster limits, the provisions on additional payments or benefits, and non-institutional NIL agreements or payments from unaffiliated entities. So what does this Q&A document say about the College Sports Commission and how it operates? Well, it essentially will have 3 main functions. The commission will conduct investigations into rule violations, will prescribe penalties for violation, and will seek enforcement of any contested penalties through the arbitration process, which, Cal, I believe you will be discussing in a few minutes. And the Q&A document, what it says about the enforcement and penalty process is that enforcement matters by the commission can be resolved by mutual agreement of all parties, including the CEO of the commission. And if not resolved through mutual agreement, if a penalty is contested by either a student athlete or a school, then they may go through the neutral arbitration process. So Cal, why don't you give us a little bit more information about this arbitration process?
Yeah, so this is a new process, of course, and the Q&A document provides some helpful information about what this process is going to be and what it's going to look like. So first, who presides over this neutral arbitration process? And as you might expect, a neutral arbitrator will preside. And that neutral arbitrator will have the authority to resolve disputes regarding decisions, including imposed penalties by the commission. Now, the arbitrator's decision is final and binding on all of the parties. And the rules actually set forth a pretty aggressive schedule for completing the arbitration process, stating that the neutral arbitrator actually has only 45 days from the commencement of arbitration to reach a final written decision, and that schedule can only be extended for good cause. Now, interestingly, during the pendency of any arbitration, whatever penalty was prescribed by the commission will be stayed, i.e., it will not be imposed, it will not be enforced. Only the arbitrator may lift the stay for good cause shown before the decision is made final. Now, in any of these arbitrations, a student athlete may be represented by counsel. And the Q&A specifically says that an institution, a school, may pay the attorney's fees for a student athlete. And it also says the school shall pay the arbitrator's fees. Now, one question I had, having gone through many, many arbitrations in my day, is, well, what about discovery? What about the hearing process? And the Q&A addresses this as well. The arbitrator has the ability to order the parties to the arbitration to produce documents if it's necessary. And the arbitrator also has the authority to call witnesses at the hearing. Okay, so we just went through the process of enforcement, what the Q&A document says about the College Sports Commission and this brand new arbitration process. So let's shift now and talk about, well, what rules are likely to be enforced? And the Q&A document provides some hints here, and we'll go through a few of those. The first of which, I think, is the topic of timing of NIL offers. And the Q&A has explicit guidance on when schools can make offers of NIL to prospective student athletes. Let's start with high school athletes. Q&A B11. B11. This is what says schools may provide written offers regarding NIL or other benefit payments on or after August 1st of the prospective student athlete's senior year of high school. But the Q&A goes on to say, the offer may not be signed until the applicable signing date specified by NCAA bylaws. So what enforcement activities could come of this? Well, certainly the timing of written offers to high school athletes could become an issue to be investigated and enforced, i.e., if a school, if a coach, if someone associated with a school makes a written offer too early, before the deadlines prescribed by the rules. Now, notably, the Q&A only addresses written offers of NIL. It does not prescribe discussions about NIL prior to those deadlines. So actually not that hard to envision investigation or enforcement activity concerning that issue. What constitutes a written offer? What if you have an email? What if you have a text communication between a school coach or school official and a prospective student athlete? Do those constitute a written formal offer, or does it have to be a formal contract? Those are the types of things that I think we will see on the enforcement side for high school athletes.
Yeah, Cal, and you just spoke about the high school athletes, and I'll discuss a little bit about transfer athletes, which I think we've noted that this may have been even before the House settlement would have been, ripe for enforcement given potential tampering. But the guidance document is clear that no written NIL offer can be made before a student athlete is in the transfer portal. the guidance is pretty clear that schools may not communicate with student athletes regarding any NIL benefits from the schools or non-institutional entities before the student athlete is in the transfer portal. And I see this, and it may be in response to the Xavier Lucas case, which we've discussed at some points in our articles and on our podcast. This is the Wisconsin student athlete who transferred to Miami, and here he requested permission to enter the transfer portal. Wisconsin denied that request, and he still transferred to Miami. So under these rules right now from the commission, it seems like this could be considered a tampering violation, as the student athlete, Xavier Lucas, was technically not in the transfer portal yet, but yet he still was able to transfer to Miami and secure a deal. Interestingly, this guidance is much more broad as what it previously was, as it forbid the school's communication with the student athlete before entering the transfer portal and does not limit it to written offers like the previous guidance that we had for NIL. Regarding the enforcement activities, I noted before, this is tampering. This is what we've been talking about, and it is likely that this is a major enforcement focus going forward.
Yeah, I completely agree, Chris, especially given the relaxation of all the transfer rules. We've talked about this. With more players transferring, with more student athletes transferring, there are just more opportunities for tampering, and I would expect this to be a major focus going forward. And the athletic department personnel and school personnel that we've spoken to all agree and are very focused on this. All right, let's talk about another topic that could be ripe for enforcement, and that goes to roster limits, which of course was a major focus of not only the House settlement itself, but all of the hearings before Judge Wilkin leading up to the approval. And let's start with talking about timing again, timing of compliance with roster limits. And the first Q&A that addresses this is Q&A C1. And it says that schools that opt into the settlement must be in compliance with roster limits beginning in the 2025-2026 academic year for fall sports, and they must be at or below roster limits by the day before the season starts, which is defined as the first day of competition that counts for championship selection. For winter and spring sports, schools must be at or below roster limits by December 1, or the end of the day again before the season starts, which is defined the same way, whichever of those two dates is earlier. And schools must remain in compliance with roster limits for the remainder of the academic year or until the end of the team's playing season, whichever is later, and the end of the season does include postseason competition.
And I think, as you noted, what was really important in the hearings was the issue of the roster limits and what to do with student athletes at schools or recruits that had started implementing these roster limits before the settlement was actually approved. And what they created was this term called the designated student athlete. And I think we need to define what that is first. I'm going to call it DSA to make this go a little quicker. But DSAs are individuals who were or would have been removed from the school's 2025-2026 roster due to early implementation of roster limits and were either certified as eligible for practice or competition or otherwise on a squad list form for the 2024-2025 academic year prior to April 7th, 2025, which was, as listeners may know, the date that Judge Wilkin had all the parties come in and discuss the terms of the settlement. And second, they must have been recruited prior to April 7th, 2025 to be or were assured to be on the school's roster for the 2025-2026 academic year. As part of these roster limits and the ability for these student athletes who were impacted, the schools must declare and identify these DSAs, as the DSAs are exempted from the sports roster limit. The DSAs must be on a sports submitted roster to participate in athletically related activities until the submitted roster expires. Interestingly, each sport must prepare and submit in good faith a list of the DSAs by July 6, 2025. July 6, 2025 is actually 30 days after the court granted final approval of the settlement. So the schools must get this in actually relatively shortly, in a few days. And the schools are not allowed to revisit or to revise its list after this 30-day deadline to submit the list to the cap management reporting system. Now, there may be some enforcement activities regarding these DSAs. Two of them that I'll discuss are timing and the in good faith language that's discussed in this guidance document. In terms of timing, the schools are not allowed to fudge the rosters after the limit for submission. As noted, they're required to submit the list of DSAs for each individual sport by July 6th and cannot make adjustments to this list. And schools that opt in during a future year cannot submit a list of DSAs because the school would not have had a prospective or current student athlete whose roster spot was impacted during the 2025-2026 year. So that means that this really only impacts, it's only a current impact for the student athlete. If a school did not opt in, obviously they would not be subject to these roster limits. However, schools that opt in later on would not have to worry or would not worry about these DSAs, as they likely would not have cut any of their student athletes to comply with the roster limit requirement. And second, I noted the in good faith language. This seems to be wide open for enforcement. The Q&A or the guidance document makes clear that schools cannot supplement the list of DSAs and must submit a list of DSAs in good faith. And so if they don't submit any of these athletes as DSAs, the student athlete will count against the roster limit and ostensibly not be able to play.
Okay, let's shift again and talk about another area that's going to be ripe for enforcement in our opinions, and that is the benefits cap. That was obviously a huge component of the settlement. It's the one that allows the schools to pay the student athletes directly. And let's start with, what counts towards that benefits cap, which is, of course, how much a school can pay the student athletes directly. Now, Q&A D7 addresses what counts towards the cap, and it talks about really two things: direct payments and additional benefits. That same Q&A also addresses from whom the payments must come in order to count, and those are by a participating institution or entities or organizations owned, operated, or controlled by participating institutions or conferences. Lastly, that same Q&A D7 addresses to whom the payments must be made in order to count, and that is to the student athlete himself or herself or to the student athlete's family. All payments that meet these criteria count towards the cap unless they are otherwise exempted, and the Q&A document actually includes a pretty handy chart of things that do count against the benefits cap and things that do not count against the benefits cap. And here's what it says. Here are the things that will count against the benefits cap: the total value of institutional payments to student athletes for the use of their NIL, other direct institutional payments or additional benefits not currently permitted by NCAA rules, Alston awards up to $2.5 million, and athletically related financial aid in excess of the 2024-2025 limit up to $2.5 million. All of that will count towards the benefit cap. Now, what doesn't count towards the benefit cap? Third-party NIL payments, even if it's arranged by the institution, funds distributed to student athletes from student assistance funds, and benefits from third parties. So, enforcement activities, what is that going to look like in this space? Well, the first and most obvious area are the characterization of payments to student athletes. Any institution that's bumping up against the cap would certainly look, if they could, to shift payments from the will count category to the will not count category. And we could certainly see investigations and enforcement over that. For example, whether payments are from a school or from a true third party. If they're from a school, they count. If they're from a third party, they won't count. So let's say there's a situation in which a third party actually pays the money to a student athlete. But what then if the school gives that third party some equal or greater benefit to essentially compensate it or cancel out that payment? Think about tickets to a game or other things like that. Really, what this is all about are indirect payments from schools using third parties as a proxy to either hide or conceal the true nature of the payment to make them not count against the cap when in fact they should. I would expect to see a lot of investigations and potentially enforcement activity into that. Another area of enforcement goes to the total value, right? For example, one could envision arrangements where an institution tries to make the value of a benefit appear less than it is, so it has less impact on the cap. Envision a scenario where, for example, a school provides housing to a student athlete and claims it's worth X dollars per month or X dollars per year when the fair market value of that rent is actually much higher. Could very easily envision investigations or enforcement activities along those lines. Another area would be routing payments through other parties. Example, the Q&A document talks about payments counting towards the cap if they go to a student athlete or the student athlete's family. What if payments are routed to a non-family member, right? It's clear that if it went to a family member, it would count against the cap. But what if it's someone who's close with the student athlete, but who's not technically a family member? Is that a way to circumvent the rule? Could we see enforcement activity there? I think it's likely. And then lastly, again, timing manipulation. Q&A D8 is clear that benefits count against a cap in the year they are provided, in the year they are paid. For example, could we see schools trying to manipulate when payments are actually made so they can, load up on student athletes, whether they be transfer or high school athlete in one year, by deferring some of the payments to the following year. So they get more than the cap value in a year, but don't pay it out until the following year. That actually could be compliant under the current rules, but it could nonetheless be a source of investigation and enforcement activity.
You touched on this cap, and the guidance documents also have a requirement that there is an annual cap-related attestation process for these participating schools. And the document clarifies that no later than September 1 of each year, participating schools must complete an annual attestation regarding the total amount and types of payments to student athletes during the preceding year. And this preceding year is from July 1 through June 30th. So who signs the attestation? This is actually signed by the president or chancellor of the school, the athletic director, and each head coach to make sure essentially that these schools, the student athletes, and everyone involved in this process, compensating these student athletes and working with these unaffiliated entities, that everything that was submitted is above board, that they reviewed all these documents and everything that has been paid to and received by a student athlete was reviewed and complies with these rules. So this document essentially says that the information provided to the cap management reporting system is accurate and compliant, that all capable benefits were included in written agreements and written agreements were uploaded to the cap management reporting system, and that the student athletes were not guaranteed payments or benefits not included in the written agreement and entered into the cap management reporting system. Essentially, the schools are attesting to that everything was reported in caps and everything was reported accurately. Now, with regard to the enforcement activities, the obvious one is the underreporting in the cap system, i.e. hiding payments or underreporting the amount of payments, or also payments outside of written agreements. This, I think, is where we may see the most enforcement coming from. There's been a lot of talk in the media when the NIL clearinghouse that's was created by Deloitte called NIL Go, which we've discussed at length, and how this may now promote under-the-table deals. While this may not stop or deter bad actors, it essentially puts the schools and the student athletes or individuals, the president, chancellor, coaches, and anyone else involved in providing benefits to these student athletes, it puts them on the hook. They'll be punished. They are signing off and swearing that all these deals were essentially above board. But I want to direct the listener to question D33, which I believe, and I think Cal would agree with me, that this is probably one of the more critical aspects of the attestation, but also of the document. And it clarifies that each participating institution must provide, and I'll quote, unencumbered access to internal or third-party auditors at any time to audit compliance with benefits pool and benefits cap rules and policies, end quote. This shows that the Sports Commission and the NCAA are serious about compliance and enforcement. And it also replaces the lack of subpoena authority, which allows now here for unencumbered access to internal and third-party auditors by the schools.
Let's shift from talking about payments from schools to student athletes to third-party NIL, which is another area that's addressed in this Q&A document and that is we believe likely to lead to enforcement activity. Now, first, the focus on third-party NIL is on associated entities and individuals. This is a key definition because NIL deals with associated entities and individuals are subject to scrutiny and analysis, whereas NIL deals with unaffiliated, unassociated entities and individuals are not. So let's talk first about what the Q&A document says. Q&A E12 talks about what is an associated entity, and it lists three things. First, an entity that is or was known or should have been known to the athletic department that exists for the purposes of A, promoting or supporting a school's athletic program or student athletes, and or B, creating or identifying NIL opportunities solely for a particular school's student athletes. Really what they're talking about here are boosters and collectives, although it's broader than that. Number two, an entity that has been directed or requested by a school's athletic department to assist in recruiting or retaining student athletes. And then three, an entity owned, controlled, operated by, or otherwise affiliated with an associated entity or individual with an exception for publicly traded companies. That's a little bit of a catch-all. So that is the Q&A document's definition of an associated entity. What about an associated individual? The very next question, Q&A E13. An associated individual is one, an individual who is or was a member, employee, director, officer, owner, or agent of an associated entity. Two, an individual who directly or indirectly has contributed more than $50,000 over their lifetime to a school or to an associated entity. Or three, an individual who has been directed or requested by school athletic department personnel to assist in recruiting or retaining student athletes. So now let's shift and talk about enforcement activity. And the big one here is mischaracterizing associated entities or associated individuals as unaffiliated third parties. And the reason, again, that a school or someone would do that is to conceal or hide from scrutiny the NIL deals, because those with associated entities and individuals will be scrutinized. Those with unaffiliated third parties will not. And of course, the definitions that I just read have a lot of gray area, which means they have a lot of room for argument and a lot of room for circumvention. Now, the College Sports Commission, with the assistance of Deloitte, those are the parties that are going to be determining who is an associated entity and an associated individual and who is not. And here's how they're going to do it according to the Q&A document. When a contract, an NIL contract, gets submitted to NIL Go, the payer, the individual or entity paying the NIL deal, again, must attest whether it meets the definition of an associated entity or individual. If a non-institutional payer cannot be verified, then the burden, interestingly, shifts to the school. It becomes the school's responsibility for determining whether the payer is an associated entity or individual. And along those lines, every school that opts in is going to be required to submit a list of all associated entities and individuals to NIL Go. They're going to have to do that every year or as requested by the College Sports Commission. So really, very quickly and very frequently, it's going to be the school, the institutions that are in the position of making determinations of whether an individual or entity is associated or not.
You talked a lot about the definition of associated entity and individual. And this is fairly important because once those entities or individuals are defined, any deals coming from them are subject to review for a valid business purpose and whether the payment exceeds a reasonable range of compensation. So what is a valid business purpose? Question E19 actually defines this and notes that an NIL agreement must include the promotion or endorsement of goods or services provided to the general public for profit. In other words, there must be a quid pro quo where the student athlete is doing something for the money. And this is similar to what the old NIL requirements under the interim policy required, which was a quid pro quo or an exchange of services. And also, what is a range of compensation? And question E20 defines this as rates and terms commensurate with compensation paid to similarly situated individuals with comparable NIL value who are not current or prospective student athletes at the institution. In other words, the amount must be paid reasonable and in line with fair market value. So what could be the enforcement activity for these types of deals? And I think there's two main areas of enforcement: the quid pro quo or lack thereof, and the fair market value. The quid pro quo would be investigated to see if student athletes are getting money for doing essentially nothing. I know that's been a big topic of conversation over the last several years. How are these athletes making X amount of dollars and what are they doing? You basically are not allowed to have what we'll call paper obligations or written in contract but not followed. Another big area of enforcement, I think maybe the biggest is what we'll see, will be regarding the fair market value payments. It will be difficult to pin down fair market value and reasonable compensation to start, given that this is a newly created area by Deloitte and NIL Go, but over time there will be more information to compare with other deals. The key is initially we'll be having some justification for amount. And as noted in previous blog posts, and as I just addressed, the NIL Go Deloitte entity that was created allows for the school and student athlete to move forward actually with a deal that NIL Go has deemed not in conformity with the rules and may not satisfy the fair market value requirement. So essentially a student athlete or a school may risk some penalty and may actually be subject to some enforcement if they are going forward with a deal that may not meet fair market value requirements.
So those are, as I said at the beginning, there's a lot more information in this Q&A document. We could spend 3 episodes on it. But I think those are the key components of the Q&A guidance that go directly to anticipated enforcement. And I'll say it again. We've been saying it here for a long time. When NIL started, the NCAA made a big deal about how they were ramping up and beefing up their enforcement staff. They got former government prosecutors, former FBI agents, et cetera, et cetera. They made a big show of it. Those folks have been sitting around twiddling their thumbs for a long time. I don't think that's going to continue. We have the House settlement that has been approved, and now we have some guidance. What is going to follow will be enforcement, will be investigations. So schools and student athletes should be ready for that. And with that, we are out of time here today. So I do want to bring this discussion to a conclusion. I want to thank you, Chris, for joining this podcast, and I want to thank everyone for listening. If you have any thoughts or any comments about the series or about this episode, I invite you to contact either of us directly. You can subscribe and listen to other Troutman Pepper Locke podcasts wherever you listen to podcasts, including on Apple, Google, and Spotify. Thank you for listening.
Copyright Troutman Pepper Locke, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper Locke. If you have any questions, please contact us at troutman.com.